Case
Hello
Law
everyone.
No. 35/2020/L, regarding the rights to establish a testament of deciding about the compensation for the state's recovery. Source of the case law, overview of the case law, content of the case, assessment of the court, rules. Approved by the Council of Judges of the Supreme People's Court on February 5, 2020 and published under Decision No. 50/QDCA of the Chief Justice of the Supreme People's Court on February 5, 2020. The
Source of
Cassation
the case
Decision
law.
No. 65/2018/GDTDS on August 6, 2018 of the Collegial People's Court in NØNG on the civil case of disputes over properties subject to enforcement in Dak Lak between the petitioner Ms. LUient T and the defendant Ms. LUient T and 09 people with the related rights and obligations. Overview of the case law. A Vietnamese allocated the agriculture land plot to a domestic user before going abroad. The domestic user used that land plot stably and permanently and was granted land use right certificates. Legal solution: in this case, it is required to determine that the domestic user had legal land use rights. The court does not accept the request to reclaim the land use right. Content of the case. In the petition dated May 9, 2012 and in the civil procedure, Ms. LUient T, who was the petitioner, stated that, in 1978, Ms. LUient T and her husband, Mr. Nguyen Sia, established a paper showing that they gifted 5 poles of land to their son, Mr. Nguyen Van D, with the following boundaries being contiguous to Mr. L's land to the east, contiguous Ms. E's land to the west, contiguous the lands of Thuong people to the south, contiguous the National Highway No. 14 to the north. In 1982, Mr. D sold the whole land plot to Mr. Nguyen Dang Yen and Mr. Nguyen Van B. Then, Ms. K gifted to Mr. D the land plot of 150 square meters without any paper, and in 2005, they gifted to Mr. D the house on this land, which was determined the following boundaries: facing to Mr. B's land to the east, facing their land to the west and south, facing to the National Highway No. 14 to the north. In 2005, Ms. K applied for the Certificate of Land Use Right, and on March 9, 2006, he was granted the certificates by the People's Committee of Peace City for the land plots. Ms. K was granted the certificate No. AD 516166 to the land plot number 9, map sheet number 58 with the area of 10.112 4M2, the use purpose of annual crops and the expiration year of 2013. Mr. C and Ms. K were granted the certificate No. AD 516165 to the land plot No. 9A, map sheet number 58 with the area of 300 square meters and the use purpose of living in urban area. In November 2006, Ms. K applied for the adjustment and regrant off the certificates of the land use rights, which complied with the building status on the land plot. Thus, on November 24, 2006, the People Committee of Peace City issued the decision number 762/QDUBND on recovering the land use right certificates No. AD 516165 and AD 516166 and regranted the new certificates No. AG 680769 and AG 680768. On June 16, 2009, the chairman of the People's Committee of Peace City issued the decision No. 1654/QDUBND to revoke the certificates granted to Ms. K and Mr. C because there were the overlap and duplication of the land plot of Mr. Nguyen Van D, who was granted the land use right certificate. Mr. K filed an administrative lawsuit against the chairman of the People's Committee of Peace City for issuing the decision number 1654/QDUBND to revoke the certificates granted to Ms. K and Mr. C, in administrative first instance judgment number 02/2010/HCST dated June 11, 2010. The People's Court of Buon Ma Thuot City refused the petition of Ms. K. In administrative appellate judgment number 07/2010/HCPT dated September 17, 2010, the People's Court of Dak Lak Province amending the first instance judgment accepted the petition of Ms. K. This judgment was protested by the Supreme People's Procureur. The cassation decision number 10/2011/HCGDT dated on November 15, 2011, the Administrative Court, Supreme People's Court cancelled the administrative first instance judgment number 02/2010/HCST dated June 11, 2010 by the People's Court of Buon Ma Thuot City and the administrative appellate judgment number 07/2010/HCPT dated September 17, 2010, the People's Court of Dak Lak Province, and handled the case over to the People's Court of Buon Ma Thuot City for the retrial. After accepting the case, the People's Court of Bournemouth City summoned Ms. K for 2 times, but she was absent. Then, the People's Court of Bournemouth City suspended the case settlement. In 2005, Mr. D used the photocopy versions of the Land Paper 1978, which was amended the position of the land plot, for applying for the Certificate of Land Use Right. At the same time, he made a written announcement on losing the original paper, and the People's Committee of E-Ward confirmed. Based on the papers submitted by Mr. D, People's Committee of P City granted the Certificate of Land Use Right with the land area of 4.9255 m2, Certificate No. AD 579302, the land plot number 09, map sheet number 58, the land area of 4.9255 m2. Thus, Ms. K filed a lawsuit to request Mr. D and his wife to return the land area of 4.6527 m2, after deducting the land area of 272.8 m2 recovered by the People's Committee of P City under the decision number 4233/QDUBND on December 24, 2010. Ms. K agreed that Mr. D and his wife used the land area of 183.74 square meters, including 150 square meters gifted and the area of 33.74 m2 on which the house located. She requested the court to cancel the certificates the People's Committee of P City granted to Mr. D and Ms. T. Heretofore, Mr. D, now dead, and Ms. T had presented, in 1978, Mr. C and Ms. K made a paper to gift 5 poles of land to him with the following boundaries: facing to Mr. L's land to the east, facing Ms. E's land to the west, facing the lands of Thwang people to the south, facing the National Highway number 14 to the north. However, in 1982, Ms. K sold 1 pole of the land plot gifted to him to Mr. N, and in 1985 she sold the remaining 4 poles of land to Mr. B. Thus, his parents agreed to gift him other 5 poles of land then. His parents left for Germany for permanent residence. Before leaving for Germany, Ms. K gave all the papers related to the land and house to Ms. E. In 2004, she returned her homeland. In 2005, Mr. D and Ms. T asked Ms. E for the papers related to the land and house, but Ms. E provided them with the photocopy versions. The papers with the stamp and confirmation of the locality government were kept by Ms. K. Mr. D and his wife made some photocopies of the papers given by Ms. E, enclosed the decisions on land allocation for coffee cultivation in 1980, 1990 of the People's Committee of P Ward, and submitted to the People's Committee of E Ward to be instructed in the procedure of applying for the Certificate of Land Use Right. They were instructed that they had to collect the signatures of Ms. K and their siblings on the papers showing that in 1978 they were gifted a house with area of 150 square meters and an agricultural land plot with area of 3.5 poles as mentioned in the original papers. Then, after being told by Mr. D, Ms. K signed a written confirmation showing that she gifted the aforementioned house and land plot to Mr. D and his wife. Mr. C died at that time. The written confirmation contained the signatures of Mr. D, now dead, and Ms. Nguyen Te. Based on the written confirmation, the People's Committee of P City granted Mr. D and his wife the Land Use Right Certificate No. AD 579302 to the land plot number 9A, map sheet No. 58 with the living area of 305 m2, and the Land Use Right Certificate No. AD 579313 to the land plot number 09. Map sheet number 58 with the agricultural area of 4.6249 m2. However, after that, on March 9, 2006, the People's Committee of P City granted Ms. K the Land Use Rights Certificate No. AD 516166 to the land plot number 9, map sheet number 58 with the area of 10.1124 m2 and the purpose of annual plants, and granted Ms. K and Mr. C the Land Use Rights Certificate No. AD 516165 to the land plot number 9A, map sheet number 58 with the area of 300 square meters and the purpose of living. They overlapped the area of land that was granted to Mr. D and his wife. After finding the mistake, on November 24, 2006, the People's Committee of P City issued the decision number 762/QDUBND on revoking the land use right certificates granted to Mr. C and Ms. K. Now, Mr. D and Ms. T did not agree on the petition of Ms. K and presented that they borrowed from Bank A an amount of VND 3 billion by mortgaging the 2 land plots mentioned above. Because they could not repay the debt, the bank filed a lawsuit and the court resolved the bank's request. Then, the judicial execution completed the auction. Thus, they requested the court to settle the case in accordance with the provisions of law. The representative of the People's Committee of P City, having related rights and obligations, presented that the procedures of granting the land use right certificate to Mr. D and Ms. T was lawful. The representative of Bank A, having related rights and obligations, presented that the mortgage loan contract signed between the bank and Mr. D and Ms. T in good faith was registered for security transaction in accordance with provisions of laws. In the civil first instance judgment number 124/2013/DSST on September 6, 2013, the People's Court of Buon-Mothuot City, Dak Lak Province, rejected the whole petition of the petitioner. In the civil appellate judgment number 07/2014/DSBT on January 14, 2014, the People's Court of Dak Lak Province amended the civil first instance judgment and accepted the whole petition of the petitioner, requested Mr. D and Mr. T return the land to Ms. K, after deducting an area of 183.74 m2 voluntarily gifted to Mr. D, on which Mr. D built a house, and cancelled the 2 certificates of land use right that the People's Committee of P City granted to Mr. D and Ms. T, Mr. D and Ms. T, Bank A, and Mr. H, who was the winner of the land auction under the decision number 47/2011/QDSTKDTM dated June 17, 2011 of the People's Court of Dak Lak Province on recognizing the agreement of the parties in the case of the disputes related to the credit contract and contract of mortgage of land use right between the bank and Mr. D and his wife had a request on reviewing the case under cassation procedure. In the decision number 343/2014/KNDS on September 2014, the Chief Justice of the Supreme People's Court suggested that the civil appellate judgment number 07/2014/DSBT on January 14, 2014, the People's Court of Dak Lak Province should be reviewed under cassation procedure, cancelled the first instance judgment and appellate judgment, and handed the case over to instance court for retrial. In the cassation decision No. for 61/2014/DSGDT on November 24, 2014, the Civil Court of the Supreme People's Court cancelled the first instance judgment and appellate judgment and handed the case over to the People's Court of Buon-Mothuot City to retrial under the first instance procedure. There were the summary assessments. The land was originally owned by Mr. C and Ms. K, but they went abroad and allocated the land to Mr. D and his wife from 1983. Mr. D and his wife were granted the land use right certificate in 2005. The agricultural land with area of 4.624.9 m2 would be recovered by the state. In the land for living with area of 300 square meters, Ms. K agreed to gifted Mr. D 150 square meters. The remaining land area was the inheritance of Mr. C, so Mr. K was not entitled to reclaim it. Besides, in 2009, Mr. D and his wife borrowed from Bank A by mortgaging the 2 land plots. Because they could not repay the debt, the bank filed a lawsuit and the court resolved the bank's request. The judicial execution completed the auction. Thus, that the appellate court asked Mr. D and his wife to return the whole land was unlawful. The legal rights and interests of Mr. H and Bank A were not protected. In the first instance judgment number 98/2014/DSST on January 14, 2014, the People's Court of Buon-Mothuot City decided to reject the whole petition of the petitioner. In the appellate judgment number 06/2016/DSBT on January 11, 2016, the People's Court of Dak Lak Province decided to uphold the first instance judgment mentioned above. After the appellate trial, Ms. NGHIjourd TK requested on reviewing the appellate judgment number 06/2016/DSBT on January 11, 2016, the People's Court of Dak Lak Province under the cassation procedure. In the decision to institute the cassation procedure number 11/2017/KNDSVC2 on February 7, 2017, the head of Collegial People's Procuratory in DÜNG City requested the Judge Committee of People's Court to try this case under the cassation procedure to cancel the first instance judgment number 98/2014/DSST on January 14, 2014 of the People's Court of Buon-Mothuot City and the appellate judgment number 06/2016/DSBT on January 11, 2016 of the People's Court of Dak Lak for the following reasons. In the process of applying for the certificate of land use right, Mr. Nguyen Van D used the photocopy versions of the papers and sophisticated the gifting agreement dated on January 2978 supplemented the confirmation of Mr. Nguyen Van S. the chairman of the Farmers Union cum chairman of the People's Committee of Ward, on November 25, 1983, which was illegal. It was illegal that the People's Committee of Peace City granted the Land Use Right Certificate No. AD 579302, the land plot number 09. Mapsheet number 58 with area of 305 m2, and the Land Use Right Certificate No. AD 579313, the land plot number 09, mapsheet number 58 with area of 4.6249 m2 on December 2005 to Mr. D's family. On the other side, the first instance and the appellate court did not verify that Mr. Nguyen Van S., the chairman of the Farmers Union cum chairman of the People's Committee of Ward, confirmed on the land-giving paper established on January 2, 1978 and did not take Mr. S.'s testimony. The case was not fully and clearly verified. The defendant stated that in 1982, Ms. Nguyen T sold a pole of the land area gift to her and Mr. D to Mr. Nguyen Dang N. The remaining 4 poles of land were sold to Mr. Nguyen Van B by Mr. C in 1985. After Mr. C had died and Ms. K had sold the land, Ms. K gifted her and Mr. D adjacent 5 poles of land. She could not verify the boundaries of the land gifted to her and Mr. D by Mr. C and Ms. K in 1978, so she did not declare. After selling the land plot, Mr. C and Ms. K gifted to Ms. T and Mr. D an adjacent land plot, Lo Dat Lien Ku. That was why she declared that the land was next to Mr. B's land and applied for the confirmation of the state-owned cinema under the Dak Lak Cultural Bureau, Farmers Association of Ward E. However, the agreement of land purchase, Mr. D was the one who sold the lands to Mr. N and Mr. B. According to the original papers provided by Ms. K and photocopy versions provided by the defendant, there were the boundaries of the land. The boundaries in the photocopy versions were edited. There was no evidence showing that after selling 5 poles of land, Mr. C and Ms. K gifted Ms. T another land. The defendant also stated that Ms. K had a written request on October 15, 2005 to confirm that in 1987 she gifted Ms. T and her husband a house and some poles of farmyard. Ms. K and the siblings in the family included Mr. Nguyen Van D, died in 2008, and Ms. Nguyen Te signed the confirmation to legalize the photocopy version of the land gifting papers as mentioned above. However, after being reviewed, those papers showed that Ms. K confirmed to gift a house with the area of 100 square meters, 5 mx 20 m, on the land area of 150 square meters, 5 mx 30 m. There was no content of gifting Ms. T and her husband some poles of farmyard. Regarding the procedure, in 2005, Mr. D and Ms. T carried out the procedures for being granted the land use right certificate to another land, not the land they had been gifted by Mr. C and Ms. K on January 2, 1978. Besides, at the time when Mr. C died in 1998, the inheritance rights of Ms. K and their mutual 14 children arose. The first instance and appellate court did not summon these people into the procedure as the people having the related rights and obligations, which violated the Article 61 of Civil Procedure Code 2005. In the cassation trial, the representative of the Collegial People's Procureur in Da Nang requested the Judges Committee of the Collegial People's Court in Da Nang to accept the protest of the head of the Collegial People's Procureur in Da Nang. Assessment regarding Mr. K and his wife's right to reclaim the area of 4,924 square meters of land that Mr. D and Ms. T had been granted the land use right certificate by the City People's Committee on December 26, 2005. The Judges Committee of the Collegial People's Court in Da Nang considered, 2, on October 2, 1978, Ms. C and Mr. K established the papers of gifting the house with area of 4 mx 12 m to their son, Mr. D, which was located on the land plot with area of 5 poles and was contiguous to Mr. L's land. To the east, contiguous Ms. E's land to the west, contiguous the lands of Thuong people to the south, contiguous the National Highway number 14 to the north. However, in 1982 and 1983, Mr. Nguyen Dang N and Mr. Nguyen Van B were transferred 5 poles of the land mentioned above. Ms. K stated that Mr. D was the one selling the 5 poles of the land mentioned above to Mr. B and Mr. N. At the same time, Ms. D denied and stated that Mr. C and Ms. K sold that land. The cassation court determined that the testimony of Mr. D matched with the testimony of Mr. B and Mr. N. Accordingly, Mr. B and Mr. N bought 5 poles of the land of Mr. C and Ms. K and paid them, record number 231, 230, 229. which was also in accordance with the fact that until 1978, Mr. C and Ms. K signed in the written papers on gifting the land to Mr. D. Thus, Mr. C and Ms. K was still the owner of the land. 3. After selling 5 poles of land which had been gifted to Mr. D, in 1983, Mr. C and Ms. K left for Germany and temporarily resided. The remaining land and house were used and managed by Mr. D and his wife. The cassation trial panel considered the fact that Mr. C and Ms. K had gifted 5 poles of land to him and his wife before they left for Germany was grounded because it matched with the statement of Mr. N and Mr. B. Mr. B and Mr. N bought the land and paid Mr. C and Ms. K. Ms. K signed in the written statement on October 15, 2005, which showed that in 1987, Ms. K and Mr. K gifted a land and a house to Mr. D, but the papers were lost. Then she signed this paper so that Mr. D and his wife could register their land use right in accordance with laws. 4. Under the provisions of Clause 5, Article 14 of the Law on Land 1987 and Clause 3, Article 26 of Law on Land 1993, the state would recover the land if the land user had not used the land over 6 months or 12 months without the state's consent. Under the provisions of Clause 11, Article 38 the Law of Land 2003 and Point H, Clause 1, Article 64 the Law of Land 2013, in case the users illegally used the land, the state would recover the land such as land for annual crops that is not used for 12 consecutive months. Land for perennial plants that is not used for 18 consecutive months, land for afforestation that is not used for 24 consecutive months. The Cassation Court considered that although Mr. C and Ms. K had used the agricultural land area of 4.6249 m2, they went abroad for permanent residing. Thus, the land was recovered by the state. Mr. D and his wife directly used the land and annually declared and paid for the tax and was granted the certificate of land use right in 2005. Thus, they were entitled to use this land legally. 5. Thus, they were entitled to use this land legally. Therefore, it was grounded and lawful that in the first instance judgment number 98/2014/DSST dated January 14, 2014 of the People's Court of Bournemouth City and in the appellate judgment number 06/2016/DSBT dated January 11, 2016 of the People's Court of Dak Lak Province, the courts refused the petition of Mr. K to require Mr. D and Ms. T to return the land. 6. After being granted the certificate of land use right on December 26, 2005 by the People's Court of P City in 2009, Mr. D and Ms. T mortgaged the land plots at Bank A to borrow money. Because Mr. D and Ms. T did not pay their debt on time, the bank filed a lawsuit against them. The People's Court of Dak Lak Province resolved and issued the decision number 47/2011/QDSTKDTM on June 17, 2011 on recognizing the agreement of the parties and forcing Mr. D and Ms. T to repay the debt to the bank. If they failed to pay, the bank had the right to sell the land use rights of the 2 plots of land. After that, the right to use the above 2 land plots was auctioned to implement the judgment execution. The winner of the auction was Mr. H. According to the provisions of Article 138 and Article 258 of the Civil Code 2005, Mr. H was the third person who has the right to lawfully use the above 2 land plots regardless to the disputes between Mr. K and Mr. D and Ms. T. 7. From the above analysis, the Committee of Judges of the Collegial People's Court in DÜNG determined that the protest through the cassation procedure number 11/2017/KN-DSVC2 dated February 7, 2017 of the head of the Collegial People's Procuracy in DÜNG to the Civil Appellate Judgment number 06/2016/DSBT dated January 11, 2016 of the People's Court of Dak Lak Province was unlawful. Thus, that protest was not accepted and the appellate civil judgment number 06/2016/DSBT dated January 11, 2016 of the People's Court of Dak Lak Province was upheld. According to Point B, Clause 1, Article 337, Clause 1, Article 343 of the Civil Procedure Code 2015, 1. Not accepting the protest through the cassation procedure no November 2017/KN-DSVC2 dated February 7, 2017 of the Director of the Collegial People's Procuracy in DÜNG, uphold the Civil Appellate Judgment number 06/2016/DSBT dated January 11, 2016 of the People's Court of Dak Lak Province, 2. The Civil Appellate Judgment Number 06/2016/DSPT dated January 11, 2016 of the People's Court of Dak Lak Province continues to be legally valid. Content
on the
of the
other
case
side,
law. In the land area of 4.924 square meters where Mr. D and Ms. T were granted the Certificate of Land Use Right by City People's Committee on December 26, 2005, there was only 300.5 square meters of residential land, Certificate of Land Use Rights, No. AD 579302, plot number 9A, map sheet number 58. The remaining land area of 4.6249 m2 at the land plot number 09, map sheet number 58 was agricultural land, Certificate of Land Use Rights AD 579313. Under the provisions of Clause 5, Article 14 of the Law on Land 1987 and Clause 3. Article 26 of Law on Land 1993, the state would recover the land if the land user had not used the land over 6 months or 12 months without the state's consent. Under the provisions of Clause 11, Article 38 the Law of Land 2003 and Point H, Clause 1, Article 64 the Law of Land 2013, in case the users illegally used the land, the state would recover the land such as land for annual crops that is not used for 12 consecutive months, land for perennial plants that is not used for 18 consecutive months, land for afforestation that is not used for 24 consecutive months. The Cassation Court considered that although Mr. C and Ms. K had used the agricultural land area of 4.6249 m2, they went abroad for permanent residing. Thus, the land was recovered by the state. Mr. D and his wife directly used the land and annually declared and paid for the tax and was granted the Certificate of Land Use Right in 2005. Thus, they were entitled to use this land legally. 5. It was grounded in lawful that in the first instance judgment No. 98/2014/DSST dated January 14, 2014 of the People's Court of Bournemouth City and in the Appellate Judgment Number 06/2016/DSPT dated January 11, 2016 of the People's Court of Dak Lak Province, the courts refused the petition of Mr. K to require Mr. D and Ms. T to return the land.